recap. Who can just give us a summary? We need someone, we need volunteers for the summary. Last week's webinar was on employers' employee rights. So what did you get from last week's webinar? Either as an employee or as an employer. The floor is open. Any volunteer? Nobody? Any volunteer? Okay, so let me give it a try. Last week, our barrister dissected employers' employee rights. Barrister CJP Ogubara dissected employers' employee rights, where he explained on the contract, as in the agreement between an employee with the employer, that there must be a contract, there must be an offer, and there should be an acceptance. That is okay, you want to work with me, you are welcome. You work with me on so terms. There should be a written document that will buttress or confirm their contract, their agreement. It's not just come and work with you, then you start working and nothing is happening. No document to back that up. No. Sorry, excuse me. So, as an employer, you have a right over your employee, and as an employee too, you have a right over your employers. One of the rights of an employee is that employees should be paid duly. You should pay your employees duly. You should pay them as when agreed. And if the employee should do overtime, it is always good to just appreciate them. While you appreciate them, it will motivate them to do better next time. Provided you have an agreement with the employee that you have to work from 8 to 6, and due to some reason, the person is now closing 7, past 7 to 7 and co. Later on, you should find a way to just compensate or appreciate that sacrifice, or him for that sacrifice, because it is a sacrifice. You just say, after all, you are working here, you are working here. You should always appreciate your employee. And employees too should also respect their employers. All the agreement they had from the beginning, while he or she was accepting the offer, he or she should oblige. Not that after I've gotten the job, now we are here, you have to misbehaving, coming late and cool. And at the same time, we also emphasize that, we also emphasize that there should be a unity among the employees. You know, we call that intra-trade union, and there should also be unity among the employers and employees, which is extra-trade union, if I'm not mistaken. Okay, inter and intra. So I'm sorry about that. So there should be a union between them. And at the same time, it is not always good for employers, after the employee has already left your organization, to now be blackmailing. It is not good under the law, except in cases whereby the company too is trying to protect some things about the organization that may be with the ex-member of the organization, which is an employee that just left. he started a case of an organization sending message around to some customers, which is not always good. It's punishable, and the such case can be taken to the court of law. And at the same time, he made mention of that, pardon me, Ms. Yonu Rebecca, kindly mute your mic. Ms. Yonu Rebecca Souki, mute your mic, please. Yes. So, you should have removed it. Uncle, you have not removed it. Let me know. Most disabled participant. Okay, I've muted. So right now, I will leave the floor for our barrister to take charge. So we address today's topic. Once again, landlord and tenant rights. You are welcome, Barrister Agubara.
Good evening, ladies and gentlemen. Hello. Can you hear me? You can hear me.
Hello, good evening.
Good evening, ladies and gentlemen.
Good evening, sir.
Yes, the last time we had a session on employment rights, or generally employment in Nigeria. The previous one, the one before the previous one, we had students' rights. Today we'll be having another section premised on titled Tenancy Rights. And once more, my name is CJP Ogubara. I'll be your chief pilot as we navigate the space this afternoon. So, of course, we always start by giving an outline of what we'll be looking at in the course of the discussion. We have 9 items on the list. First is an introduction. Second is a tenancy as a contract. Third is essentials of a tenancy. Fourth is the exclusive possession. 5 is rent. 6 is termination and renewal. 7 is recovery. That should be recovery, not recovery of possession. Recovery of possession. 8 is statutory notices. 9 is the conclusion. Like as we always have, we'll start with an introduction, general introduction. This general introduction will cover a subject, tenancy generally, talking about everything that a kind of summary of what we'll be looking at as we go in. And we started by asking who is a tenant and who is a landlord. You know, as a lawyer and as people of understanding, when a law has called something called a subject, a particular name, for you to have decency, it is better to stick to what the law has called it. Basically, we're in Ogun State, and I believe my audience are people resident in Ogun State, Abeokuta, Ogun State generally, because as we navigate through, we're making use of the Ogun State law, tenancy law, which I will give you the title as we move on. First of all, what we have is who is a tenant and who is a landlord. And like I told you, we'll be making use of the law on tenancy in Ogun State, which is residential premises in brackets, rent control and recovery of possession law. It is contained in volume 4, the laws of Ogun State of Nigeria 2006. If you look at pages R27 up to R up to R89, up to R89, yes, you will see every information regarding the residential premises, rent control and recovery of possession law of Ogun State. Now, the law has defined who we should call a tenant. And that's found in section 2 of the interpretation of section 2, titled Interpretation of the Residential Premises, Rent Control and Recovery Possession of Possession Law of Ogun State. First, it defines tenants as to include a subtenant or any person occupying any premises, whether on payment of rent or otherwise, but does not include the wife, child, parent, dependent of a tenant or a subtenant or a person occupying premises under a bona fide claim to be the owner of the premises. I will explain this. Like I said earlier, everything we'll be discussing today as regards to tenancy will be drawn from the law of tenancy in Ogun State. I believe so much in the law. What I feel, how you feel, does not matter. What matters is what the law says about a subject. If the law calls it white, it has to be white, irrespective of what we're saying. So I believe so much in law because law is the background thing that regulates the rights that we'll be talking about as we go through this subject. So, as I said earlier, it says tenant includes a subtenant. Now, who is a subtenant? There are situations where you see a landlord and a tenant having a contract, and in that contract, you see clauses like right to sublet. If you sublet, the person you have sublet to is a subtenant. You are not the landlord. The landlord remains the landlord. Because in that initial contract you have with your landlord, there will always be a further clause that says you cannot sublet without the consent. In fact, the consent will always be a written consent, not oral consent. So, whoever you sublet your premises to, or the premise of the demised premise, becomes a subtenant to the landlord, not to you, although you may have benefited. That's why you will discover that in the course of this discussion, rent is not a sine qua non for the determination of what constitutes tenancy. Yes, it forms part of the consideration, but as we go through, you discover that one can be a tenant without even payment of rent. What are the categories? Okay, the next thing we will be looking at, I don't know. Okay, subtenants, I've described subtenant. And then the law of others says any person occupying any premises, whether on payment of rent or otherwise. You now see what I said initially, that payment of rent does not necessarily say or dictates what constitutes tenancy or not. You can see what the law says, payment of rent or otherwise, but does not include the wife, the child, parent, or dependent of a tenant. So a situation where you go, you want to be a tenant, you meet your landlord, and the landlord contracts with you in your name and his name, and later you discover that the quit notice or all other statutory notices begins to come in the name of your wife. That is trash. Or in the name of your children. That cannot stand in law. Now, where it comes in the name of Mr. and Mrs., if the name of the tenant is omitted on the document, that is also absolute trash. But where the name of the tenant, we'll call it tenant on record, the name on record. Where the agreement comes in the name of the statutory notice or any form of notice or communication comes in the name of Mr. and Mrs., including the name of the wife. When we go to court, the court will reckon with the name of the tenant, ignoring the other name that appears there. The law will consider it a surplusage. But where there is no name of the tenant on the document at all, then the law will not reckon with it, because there is what we call privity of contract. Privity of contract, as we go into contracts, we will also look at that. Privity of contract comes into play where the law says it is only those who are contracting parties, beneficiaries of a contract, that can raise questions as regards to the contract. So a wife of a tenant cannot be reckoned with under the principle of privity of contract. The child of a tenant cannot also be reckoned with under the principle of privity of contract. All right. So now it also says does not include dependent. When you talk about dependent, you can also be looking at your maid, your housekeeper, and the rest of them. So also as it applies to the subtenant. Now, a tenant does not include somebody who is occupying a place under the belief that he is the owner of that premises. Now, you'll be asking yourself, how can somebody come and live in a place that is not his own, but exempted as a tenant under the claim of bona fide claim of right? I give you an example. I traveled to England. I met Mr. Accurate in Manchester. And he called me. We sat over some meals in the evening, had some wine, and we became friends. In Manchester, I mentioned. So later, he was returning to Nigeria, and he called me. Look, Oga, I need to be in your house. Oh, something happened. They are doing some renovations in my house. And then I asked him to go and occupy a certain place. Now he went there. By the time he got there, he is a licensee. Then he called me up again, and when he told me, I told him number 56A. Wrongly, Accurate got to number 56B. And coincidentally, the key to number 56A can also as well open number 56B. Remember, 56B is not my property. When he got there, he said, I like this, your property. I want to buy. I said, okay, pay me 50 million naira, and he pays the money. You remember, he entered there as a licensee, and he's living there. Don't forget, that is not my property. Now, the owner of the property comes up one day and says, Mr. Man, what are you doing on my property? This is my property. Now, what are you doing here? I'm trying to paint a picture of somebody who has bona fide claim of right. Remember, Accurate believed that the number 56B was actually my property, not 56A. So, but the owner of 56B has shown up to tell him, look, this is my property. You are mistaken. The lawyer you are talking about, his own is 56A. So at that time, anybody that tries to question Accurate of his presence in 56B, Accurate can lay claim to what we call bona fide claim of right, because at that material time, he believes that he is the owner of that property. So that's what the law contemplated by under a bona fide claim to be the owner of the premises. So then another thing I also mentioned there is who is a landlord. Now the law says a landlord includes a sub-landlord. Remember, I said you were not a landlord when I was defining tenancy. I said you were not a landlord. Deliberately, I did not mention that you are a sub-landlord because I was going to give a discussion on landlord. Now, like I painted earlier, a sub-landlord now takes the position like the way the subtenant took the earlier position. You that the landlord has given the outright right to sublet. You are now the sub-landlord to the lessee, that's the subtenant that you have let into the property. That is where you are a tenant resident there. But there are instances where a tenant may not even be resident there, but you are still a tenant. And to this person, you are still his sub-landlord. So who is a landlord? A landlord includes a sub-landlord and any person from time to time deriving title from or claiming through the original landlord. Now remember, this is a premise, this is a property. It can be sold from time to time. So at every point in time, any owner at any point in time becomes a landlord. That's why the law contemplated from time to time. So the law did not put it definitely on the original owner. So the law contemplated from time to time. So from time to time, landlords can vary. From time to time, landlords can change. So, and also any person receiving, whether in his own right or as an attorney or agent, any rent from any person for the occupation of any accommodation. So you discover there are two things that I mentioned while we were describing. There were further mentioned. One is an attorney, another is an agent. An agent, we see most of them in Abeokuta here. A lot of people are into agency business. But unfortunately, most of them do not have the trainings. So an agent is somebody acting for the landlord. An agent can as well be an attorney. So a landlord is somebody who hands over his property to you. By the time we go into the contract, I will be able to explain it very well, the contract aspect of tenancy. So we'll move into tenancy as a contract. You know, I said it earlier. A tenant makes an offer to the landlord, or a landlord makes an offer to the tenant. Any of them who accepts, the offeror becomes the landlord if it is the tenant that is accepting. But if it is the landlord that is accepting, then the offeror becomes the tenant. Offeree becomes the person who will be accepting. So there has to be offer acceptance consideration. Like I said earlier, I told you that rent is not so much as important as the tenancy itself. Now, there can be tenancy without rent. I give you an example. There's what you call customary tenancy. Customary tenancy doesn't apply to built up property. It applies to empty land. Where you have in villages, people have ancestral lands that they will allow people to pay what we call shakole. I don't know if I'm right, you know about the shakole. People pay certain things, but we'll not call it rent. We'll call it tribute or royalty. So rent is not the same thing with royalty. Rent is also not the same thing with tribute. So that's why I said rent is not a condition, it's not a paramount, it's not as important as the tenancy. So the landlord gives up possession. That is the consideration. When we go into exclusive possession, we begin to understand what I meant by rent is not as important as the tenancy. Now, the landlord gives up what we call possession, and the tenant takes up possession. That possession you are taking up is the consideration. That possession the landlord is giving up is a consideration. Now, what you as a tenant gives in exchange for the rent, in exchange for the tenancy, like I said, it could be shakole, it could be in kind. You may compensate, you may tell the man that you will marry him. You may tell the man, my son will marry your daughter. The man may have a daughter who is not marriageable, and the young man comes in and says, "Oga, I can marry this, but you cannot call that rent." That's a consideration. The landlord can as well give up that possession for you to take care of the entire premises. So by the time you are taking care of that place, that's a huge consideration for taking over the premises. So I mentioned capacity. Can a child be a tenant? Can a madman be a tenant? The answers are no, no, and no. So tenancy and other contractual relationships. Tenancy is like a sui generis type of relationship, contract relationship. In tenancy, you can contract with the landlord, and the kind of considerations you have in tenancy is not the kind of consideration you see in other contracts. In a contract of sale of goods, the consideration will usually be money or exchange of goods. You can exchange Toyota Corolla with Honda Hala or Honda Accord. That is also contract. But in tenancy, it is either for rent or for other considerations other than money. Now, I mentioned limitation of the law by agreements to contract. Now, the law is clear as to things that operate in tenancy. But where you and your landlord decides to contract, that's why when you are going into a tenancy contract, it is important for you to have an agreement written down. Now, when you're having an agreement written down, don't just go and sign the paper. Take your time, read it, and have it interpreted for you. Meaning, you should also engage a lawyer. When you approach a landlord for a tenancy, and the landlord insists on having only his lawyer, you have the right to object. Yes. You can say, landlord, sir, I'm sorry, but I have my own lawyer. And you are not desperate. He's not at you are not at his mercy. It's a business, it's a contract. If you say you are not staying, the landlord is losing money if the consideration for the tenancy is rent. Whatever the consideration is, if you are not taking over the premises, the landlord certainly will lose that consideration. So by the time you look at section 14 of the residential premises rent control and recovery of possession law of Ogun State, you will now understand. I read, where there is no express stipulation. What is that express stipulation? The express stipulation is the tenancy agreement. If there is a tenancy agreement stipulating that, look, there is nothing like notices from the 1 to the 31st, from 1st of November to the 31st of October, from 1st of November 2023 to 31st of October 2024, the tenancy ends. That is what is called a fluxion of time. Once that eve of 31st reaches, you are no more a tenant in that premises. The law at best can call you statutory tenant, but you are not a tenant. Even though the period you are staying, you will pay mean profit for it. But at that material time, from that 31st upward, you are not a tenant in that premises. And now, I don't want to spoil your mind, but people like me, since I believe that you are not my tenant, I can get into that place. You cannot sue me for trespass because the only person that can sue for trespass is the tenant. Like if you see, one of the outlines we have is trespass. Under exclusive possession, we'll look at trespass. Whether your landlord can come into your premises at will, without notice, without information, whether your landlord can just enter the premises, we'll look at that under exclusive possession. So now the opening paragraph of section 14 says where there is no express. So if there is express, that means that express is talking about tenancy agreement. So it's very important for you to always go for tenancy agreement. You don't just pay for the agreement and you don't show up to sign it. Sign it. That is what regulates the relationship between you and your landlord. Whatever the tenancy agreement has not captured, except what is custom or customary with tenancy, of course. One of those things customary with tenancy is payment of outgoings. If there is an electricity bill that requires payment, you don't need the agreement to state it obviously. You need to pay your electricity bill, water bill, and all other utility bills that are appertinent to that premises where you stay. So now we'll go into essentials of a tenancy. There are 4 essentials that must be present in every valid tenancy agreement or tenancy contract. The first one is certainty of property. The property must be certain. You know, the initial example I gave, I deliberately gave that example because it will help us as we go in. And one of the areas it will help us is in the area called certainty of property. See, when we are contracting, the property we are contracting on must be certain. You know, I mentioned 56A, but accurate was mistaking me for 56B. Now there is no certainty, and there is a problem. Sorry for the interruption. I mentioned that there are 4 essentials or basic ingredients that are necessary in a tenancy contract. The first one is the property must be certain. If we are contracting, if we are having a tenancy contract, we must be specific as to the property we are dealing with. If it is an estate, for example, Ibarra Estate, Ibarra Housing Estate, or if you know Orange Valley, the one opposite, the one within Olusegun Hilltop Estate, Olusegun Obasanjo Hilltop Estate, after governor's office or opposite governor's office, there are quite a number of duplexes there. So let's say the property I'm talking about, they are numbered according to A, B, C, D up to Z. So if I'm talking about property H, then it has to be certain in the tenancy, so that I don't talk about property H and I couldn't get himself in property G. You discover that there is no certainty of property. Number 2, there has to be certainty of parties. You know, I mentioned the issue of privity of contract. If tenant and landlord are contracting, we must be specific, accurate foundation, and CJP Ogubara, the landlord and tenant, is clear. So it does not turn out to be, it's my father, yep, I'm the landlord. No, whose name is on the contract paper? Sorry. Certainty of parties. The parties must be certain. You cannot come and take up tenancy and then give it to your sister to be living there. If your sister is living there, she's merely a licensee. Remember, when the law was defining tenants, it says excludes your wife, your children, or dependents. So your sister can be categorized as a dependent. So your sister is not a tenant. So by the time there is landlord and tenant meeting and somebody sees your sister, you know, it's awkward. A dependent is not mentioned among the tenants. So the landlord has rights to chase your sister away. And if the landlord chases your sister away, don't come and say, I sent representative now, excuse me, landlord and tenants meeting. Who is the tenant? You are. Where were you? You were not in the meeting. You sent representative. You don't have any authority to do that, except by mutual agreement. You tell the landlord, please, sir, let me send one of my dependents, but not coming as a tenant, coming to listen and communicate to me because I am not within reach. That is polite enough. So I mentioned certainty of parties. It has to be XYZ as the landlord, AB as the tenant. And it can no longer, it cannot be AB at the initial stage and later it becomes CB. Now, if C wants to have a tenancy, if CB wants to have a tenancy contract with the landlord, AB should vacate the place and then CD should negotiate new contract. Now there has to be duration. Now, you know, I said it, that by express agreement, the parties can state the duration of the contract. If it is commencing from the 1st of November and ending or terminating, if it is an annual tenant, for example, commencing from 1st of November and terminating 31st of October, then there is what we call duration. It is specific. From that time to this time, you are tenant. After the eve of that night, you are no more a tenant. At the eve of that night, you are no more a tenant. So there must be certainty of duration. If it is 1 week tenancy, we are contracting on a weekly tenancy. If it is monthly tenancy, we are contracting on a monthly tenancy. If it is annual, we are. If it is quarterly, we are. If it is 6 monthly, we are contracting on that basis. This is very important. Then number 4, exclusive possession. You know, I said it, that we'll be talking about exclusive possession is a consideration the tenant is benefiting from the tenancy. When the landlord gives up possession, the tenant gets what we call exclusive possession. What is exclusive possession? Exclusive possession is the right that arises when a tenant takes over a place exclusively. Now, by exclusive possession, you cannot be entitled to sue for trespass. You can sue the landlord for trespass if the landlord commits trespass on the premises, because what you are holding is possession, and the law recognizes the one with possession even more than the owner. What the law usually do is to make a presumption that the one in possession is usually the owner. But that presumption, the law has a rebuttable presumption. Now, what makes something a rebuttable presumption? Like I said, the law assumes the person in possession as an owner. Now, that presumption can be rebutted by the owner coming forward and saying, no, he's just only an occupant. He's just only in possession. I am the owner. I relinquished the possession to him, and he was enjoying exclusive possession of the premises. So these are the essentials of a valid tenancy. Exclusive possession. What are the things involved in exclusive possession? We have non-interference, peaceful use. You see those in most of the contracts you sign. The landlord we covenant to give you peaceful enjoyment of the premises. The landlord will not just come in as he wills. Coming into the premises, he requires notice. He must inform you. Except where the premise is jointly possessed. Well, let me say the premises is a 10-unit self-contained apartment. So you know you don't have exclusive possession of the entire premises. Where you have exclusive possession is the room you occupy. So the landlord can come into the premises at will. Because remember, you are not having exclusivity of the entire premises. I don't know if you are getting me. If it is a 10-room self-contained, the entire premises does not, you don't have exclusive possession of it because other tenants are there. And because other tenants are also there, they also do not have exclusive possession of the premises. So at that point, the landlord is free to enter the compound and inspect. But he cannot enter your room without notice. It is your room that you have exclusive possession. So trespass. What is trespass? Trespass is a tortious injury on the rights of the person in possession. Don't forget the things that I've mentioned. I mentioned injury. I mentioned civil injury or tortious injury on the rights, because I want to distinguish it from trespass to person. An example of trespass to person is me slapping Mr. Accurate. That is battery or assault. That is an example of trespass to person. So when we talk about trespass to property, we are not talking about this very trespass. So, and then when you talk about trespass to property, you are talking about the right somebody enjoys. Because don't forget, the possessory right you're having on that property is not definite. It has a time. Remember, when we are talking about certainty of duration, we mentioned the time. So now, if you are talking about trespass, the right you are enjoying that you can sue on if there is a trespass on that right. So, but where the man enters the place on the 31st, you know you are not a tenant. 31st of October. After 31st of October, 1st of November, you are no more a tenant. So you cannot talk about trespass again because you don't have exclusive possession anymore. That possessory right you are enjoying has been determined by a function of time. So when a landlord enters a premises without notice, you can sue him. So that's the one of the things right of a tenant, exclusive possession. When that exclusive possession is by any chance, is a right, by any chance infringed upon by the landlord, you can sue the landlord. Battery is running low. Let me quickly exit and then share it. How do I exit from here? Excuse me. So we're talking about, sorry, there was a little interruption. The laptop went off. We're talking about exclusive possession, trespass. notice to inspect. Now, when a landlord wants to come into a premises, he must give the tenant notice before he can come into the premises. And what are you even going to inspect? If there is a leakage, or if there is an information that something has escaped, you know, some houses are built in a way that one connects to each other, and there is an escape of an object from that your premises where you are having an exclusive possession to another place, then definitely the landlord will need to inspect. Or if somebody is saying, another, or your neighbor is saying something escaped from your apartment into his apartment, there is need for an inspection. And when the inspection comes up, the landlord will need to give you notice to be able to inspect the place. Now, when notice is given, you have right to say, landlord, please, this. But don't forget, where one man right ends, there another person's anything. Where one man freedom, one man right ends, there another man's freedom. One man's right ends, where there another man's right begins. Sorry. So at the time your right is ending and another person's right is beginning, then your own duty is also beginning. What is your duty? You have a duty to make sure that your landlord and co-tenant, that's your neighbor, does not suffer things escaping from your apartment. So you have a duty to make sure that things do not escape from your premises. So that's a duty. Like I said, where your right stops, there begins another person's right and freedom. And then where another person's right begins, there also your duty starts. If I have a right to be in this place, then you have a duty not to come into my space. So after, like I mentioned, you can sue your landlord for trespass if he enters the place without taking permission. Another thing we'll talk about is rent. Payment of rent and other outgoing. You know, I've talked about exclusive possession. And like I mentioned earlier in the beginning of this discussion, I told you that rent is not as paramount as the tenancy itself. Now, where rent is an integral part of the tenancy, or where rent is the consideration for the tenancy, then so many things must play out. You see, there are situations where landlord increase rent without at will. I'll shock you what the law says. I want you to go on this ride with me. The law says in section 3 of the residential premises rent control and recovery. Remember, it says rent control. You know, I mentioned it earlier, rent control and recovery of possession law. Do you know that it is the duty of the executive governor of Ogun State to fix rents? I will read section 3 of the law for you, or to you. The governor may, by order, fix the standard rent payable in respect of any residential accommodation in any town, place, or area to which this law applies. Don't forget, this law applies in all the areas in Ogun State. Be it Ijobode, be it Songo, be it Akomoje, be it Elaro, anywhere, you know, Waterside, anywhere in Ogun State, this law applies to it. So the person who fixes the rents in the state, it is the duty of the governor. Probably Dr. Abiodun doesn't even know this. But is that obtainable today? The answer is no. Now, one of the things I stated is statutory notices. How does rent and statutory notices come together? If your landlord issues statutory notice to you and he has given you notice of when to give up possession or deliver up possession, but later you went and paid rent to him, that rent, remember I said later, you went and paid rent to him. That rent you have paid, if he accepts that rent, it has overwritten the notice he has issued to you. I need to make this clear before I go into notice properly, because notices, statutory notices, is a topic on its own that we are going to discuss now. So rent is something that the governor fixes. The landlord cannot wake up and increase the rent at will or as he pleases. He has no such right. Now, it is also prohibited under the law for the landlord to increase rent in excess of what the law has stated in an area. For example, if the governor has fixed Quarry Road that a room self-contained will go for 200,000, the landlord has no right or power to increase it in excess of 200,000. If he does so, you can revoke. And if by any chance he determines your tenancy on that basis, the court will override it. The court will upturn it. If he issues quit notice to you and comes under anything, in the course of the trial, you can raise it. That it is because you questioned his power to raise the rent beyond what the law has mapped out for that area. That is why he issued, provided you can be able to prove it. That is why when a landlord is telling you that he wants to increase the rent, please tell him to put it into writing. And by the time that is done, find out what the law have said about this area. Of course, I'm a lawyer. I will tell you the black and white law. I won't look at what your feelings are. I will tell you what the law says. Now, one of the things I listed is termination and renewal of tenancy. You see, every tenancy, except where the law says, where the agreement says at the eve of the tenancy. For example, I gave you an example of 1st November to 31st of October. On the 31st of October, your tenancy ends. That's what the agreement says. But now, if there is no such agreement, if it is not stated, if you simply entered there and said, we'll be having our tenancy, we'll be going or we'll be paying rent, then the landlord cannot eject you without reckoning with the law. What did the law say? The law says under section 14 that where there is no express stipulation as to the notice to be given by either party to determine the tenancy, the following periods of time shall be given. In the case of a tenancy at will or a weekly tenancy, a week's notice. In the case of a monthly tenant, a month's notice. In the case of a quarterly tenant, a quarter notice. In the case of a yearly tenant, half a year's notice. What is half a year? 6 months. So you cannot terminate or determine a tenancy without appropriate notices. But don't forget, I said if there is an agreement, and the agreement, as we stated earlier, on the essentials of tenancy, duration, certainty of duration. If the duration is certain, then you wouldn't have any need for notice. If the duration is certain that on the 31st of October, your tenancy ends, you don't need any notice to be given to you. The landlord can determine the tenancy without notice, because once it is 31st, the tenant ends. But where there is no express statement as to that, then you will reckon with the notices in the law, which is, if it is monthly, a month notice. If it is quarterly, it is a quarter notice. If it is weekly, it is a week notice. If it is the annual tenant, it is 6 months notice. I don't know if I'm flowing.
Yes.
I hope
Yes, sir. Let's say 20 minutes. 20. Okay, good.
Now, another area to cover is termination. Oh, I've mentioned termination, renewal. Renewal of the tenancy. Now, like I said, on the 31st of October, you are aware that your tenancy has expired. So you have intention to renew it. Don't wait until 31st before you begin to talk about renewal. If you are entering towards 2 months into 31st, that is August, by August, it is expected that you write to your landlord and communicate to your landlord, or show your landlord that you have an intention to renew the tenancy. At this point, you are making another offer. Remember, tenancy is a contract. You are making another offer. You are now the offeror, and the landlord can say, no, I don't want you to renew the tenancy. I want to give it to my son. Or my son is coming back from the United States. He needs to make use of the apartment. So he will not accept it. But where he accepts, acceptance has taken place. Now you pay the tenancy. By the time you people agree, you can agree to pay the tenancy immediately, even though the current time has not elapsed. That's between you both. But whatever amount whenever you pay, it cannot start until the current one is determined by the 31st of October. Is that clear? So if it is not determined, then you have given him money to hold on, but tenancy has not started. But there has been a contract that has not commenced. You know, when you see a contract, you will see this contract shall commence so time. So it doesn't mean that it is the time it is executed that it will commence. Some contracts can commence in future time, even though it was entered in today. So that is for that. So when you now issue your landlord the notice of your intention to renew the tenancy, and he accepts, another contract has been vetted, like I said. So that is for renewal. And new rights, new obligations, new entitlements may also arise, depending on what is applicable. Now, where I'm going into, before I go into recovery, I want to mention an important area which has been causing problems between tenants and landlords. I've mentioned the issue of notices, right? The length of statutory notices. Now, issue of electricity and other utilities. When you are getting into an apartment, please be careful what you are contracting on. Make sure your terms are stated. Are you the person to pay for the electricity bills? Are the electricity bills independent of, for example, somebody that enters, a lodger that enters into a hotel doesn't pay for electricity, separate from the lodgement money he pays to the owners of the hotel. So you have to be sure that you agree with your landlord that the money you are paying does not include electricity, because the tenancy agreement will state it clearly that you agree to pay all outgoings, all utility bills, which includes electricity. Now, if a landlord keeps quiet on that contract, it is assumed that the money you are paying covers the electricity and other utilities, including water. And then for tenants, make sure the terms are stated clearly. Landlord, the money I'm giving you includes water. The money I'm giving you includes security. The money I'm giving you includes this. So if the landlord says no, it does not, then you know your options. What are these outgoings that I will be meeting in the time, by the time I'm living in this place? So that if the landlord now keeps quiet, by the time you are living there, the community comes and tells you, Oga, pay your security levy. Security levy is 30,000, whereas the amount you paid for the tenancy is not even up to 30,000. You know there is a big problem. So you need to know all these things. So I go into recovery of possession. Now, in recovery of possession, when a landlord, be it by agreement or by statutory notices, once the tenancy has elapsed or determined either by quit notice or by a fluxion of time. A fluxion of time, I mean 31st of October as the example I was using from the beginning. That is a fluxion of time. But if it is determined by notice, then there are two important notices that a tenant must get. The first one is what we call notice to quit. If your tenancy is to be determined by statutory notices, the first one is notice to quit. The second one is notice of owner's intention to recover possession, or 7 days notice. Now, 7 days notice is given to you if it is a tenant that is an annual tenant. Your landlord is expected to give you notice 6 months into the tenancy. For example, you packed in 1st of November. The landlord is expected to issue you notice by November, December, January, February, March, April. By April, your landlord is expected to issue you notice that will end by October 31st. If he doesn't give you notice before April and gives you that notice after April, and the law says it is 6 months, then your 6 months will at least 31st of October. If he issues the notice to you by May, He's not expected to come and be talking about getting you out because 31st of October has reached. No, you are entitled to 6 months notice. And that 6 months notice, he gave it to you in September. Just barely 1 month to the end of your tenancy. He will wait for extra 5 months. Now, what will happen the period of that 5 months? Are you going to pay? Yes, you pay what we call mean profit. What you are paying within that 5 months, you know, he has issued you the quit notice September. So, and then your tenancy is expected to end by October 31st. That 6 months notice must stay till September, October, November, December, January, February 2024. But you must pay mean profit. That mean profit is the amount you paid as rent for the period of 6 months. Sorry, for the period of 5 months. Because already 1 month has been captured from that 6 months. If you issued it September, let's say 1st of September, then September, October, 2 months, sorry, not 1 month, 2 months. So you will be paying mean profit for 4 months, not 5 months. And now, if he goes to court after that February, you know, like that 6 months will end by September, October, November, December, January, February. So that 6 months will terminate by February 28th or 29th, depending on the month, the calendar we are using for that year. So if you did not vacate and he proceeds to court, till the time you stay in that premises, you will still pay the mean profit. It's not that the landlord, the court will now order you to vacate. You now say, okay, you must you must pay the money that will cover from November up to the time you vacate that place. Be it February, when the 6 months will end, you must pay mean profits. You will not live there for free. If you don't pay it and vacate the place, the landlord will sue you and recover that money. Now, recovery of possession is after he has issued that notice to you, you later deliver up possession peaceably. He has recovered the possession. But after that 6 months has elapsed by February, you are also entitled to what we call 7 days notice. It's called notice of owner's intention to recover possession. If he doesn't give you that 7 days notice, the court will frown at it. The court will not entertain such claim. There must be 7 days notice. For both the one determined by statutory notice and the one determined by explosion of time. If by 31st of October, for explosion of time, and you refuse to give up possession, he can quickly give you 7 days notice of owner's intention to recover possession. So after that 7 days notice of owner's intention to recover possession, he can do you anything. Yeah. Because remember, your tenancy is not determined by statutory notices. It is determined by the agreements you have already signed with him. So I think I will use the remaining 10 minutes to entertain questions.
Thank you very much, Barrister. We are very grateful for this priceless lecture. So we'll now leave the floor for the members. If you have any question, you can type it to the chat section or you signify by raising your hand. Any question from the audience? You have had a lot now. No landlord can just tell you, leave my house. I'm bringing thugs, come and send you out of the house tomorrow. That is impossible. You have right under the law. If you are paying for 1 year, you'll be given a notice of 6 months. After that 6 months expires, though you will pay for that 6 months, after the 6 months expires, you'll be given another 7 days. Notice of owner to recover possession. So all these are normal things that we should know and that we should do in case we fall in such situation? Any question from the audience? You can signify by raising your hand or type the question in the chat section. So I believe what you have said since is clear to everybody. But I myself, I have questions, sir.
Go on, sir.
Okay. The first question is this. You said towards the expiration of every tenure, we should write a letter to our landlord to show the intention that we still want to retain the apartment or the premises. Okay. We hardly do that. It's just a matter of when the tenure is about to expire, the agent will just contact us. Hello, your money is about to expire. Pay in time. Pay so time. And code, they will make payments. Writing the letter to that landlord again every year. Are you not giving the landlord an opportunity to just pay the price or do anyhow?
You see, nobody is at each other's mercy. Like I described earlier, I said tenancy is a contract. Everybody is benefiting from it. The landlord is getting probably his rent or whatever consideration other than money. So if he's getting rent, which is money, that's the consideration he's getting. So what is there is this. He needs the money. And telling you that he wants to increase land, you tell him, okay, I cannot stay. You vacate his premises. Are you telling me that you want to exploit the landlord? Of course, he cannot. You know, that's why they say it is the duty of the governor of the state to fix tenants' rents. The landlord cannot arbitrarily increase rental values for properties in certain areas, which the governor would have designated and mapped out. So, I mean, you know, the problem is most people that are into tenancy today that call themselves agents, they don't even know what it means. They feel it is business, bring money, some will do this, do. There are so many things involved in tenancy. Do you know that somebody can come into a premise and die that place? At that point in time, you don't know the occupier. There's what they call occupier's liability. If I come into a premises and something happens to me, it is the occupier of that place that is liable in law. Tenancy is not what you do. It's a serious business. That is why a landlord should always be held responsible. For example, the issue of accumulated bill. If a tenant comes forward and pays and contracts with you, and subsequently you are not drafting new contracts with him, and by the time the tenant abandons that place, and the electricity utility companies are coming telling you that the tenant owe them some money, and you say no, no, telling you that this apartment is owing us some money. I say no, there was a tenant there, and then they tell you no, there is no evidence that there was a tenant there. You bring, what agreement are you going to bring? You bring an agreement when the tenant was complying. Do you now understand it? Why it is important to always renew? Draft new contracts. Immediately the tenancy is expiring, put up a new contract. It's not going to cost you anything. If worst case scenario, it will cost the money for. The problem is that people don't like paying lawyers. The money for your lawyer to get the agreement done. But it's understandable. You can have an understanding with your landlord that, look, landlord, this your lawyer cannot be collecting the same amount, 10% of the same amount all the time. since I'm going to be renewing almost every year, then why can't he be taking half of the money or certain percent of the money? The lawyer can be considerate because this is something that happens every other year. But whether it is important to be drafting the contract every year, it is very, very important for the sake of the landlord and for your sake, for your protection. Now you are living in an apartment and you want to apply for visa, or you are living in an apartment and somebody gets, you are found somewhere in the middle of the night and security arrests you and they want to charge you for wandering, or they call you a vagabond that you don't have a place. They want to charge you for wandering. Wandering is a crime under the law. I think we will also schedule a time for criminal law generally. Wandering is a crime. You can't just be wandering about. So by the time they arrest you, maybe there was a raiding in the town, there was security threat, and the security is at alert, and they decide to carry out a raid, and they pick you up. What contract are you going to show your security? The security that arrested you, to show that you have an apartment where you're living. You begin to look for your landlord. What if your landlord is living abroad? Now you want to tell me what if receipt was issued? Let me tell you. I want to tell you something. Tenancy is dealing on land. And the law says, if you want to receive anything, go into any contract that deals on land. Receipt is not enough. It has to be in writing, either by way of deed or by way of normal writing. Receipt is not sufficient. You need to have your tenancy by deed, especially if it is a lease. So if you are under a lease and then you are presenting a receipt, the security people, if they still want to press it down, they will tell you, oh God, what you're bringing, we don't know what it is. Anybody can bring up any receipt. But don't forget, when it is a lease or a tenancy agreement, there is a proper contract. If he looks at the receipt, he will tell you, you are bringing a receipt. What is the contract? What shows that there is a contract between you and your landlord? Of course, don't forget, tenancy is a contract. And can a contract be represented in a receipt? Can a receipt say you're right in the contract? Can the receipt say that you are resident in so place? Can the receipt say that you are enjoying exclusive possession? So if the landlord gives you receipt and tomorrow he enters your apartment and you say, I have exclusive possession over this thing, he will tell you, where is that expressed? Do you now understand why receipt is not sufficient? So you need to have a proper documented agreement to cover your tenancy. So coming to his question, that area that it will make the landlord to want to increase, no. Remember what the law says in section 3 and section 4 of the residential premises rent control and recovery of possession law of Ogun State. It's clear that the landlord cannot arbitrarily increase rents where the governor has stated an amount for this area. So
hello.
Hi. So we have Galaxy one raising his hand.
Okay. Hello. Okay.
Yes, I'm with you.
Yeah. Thank you. Thank you, Barrister. Thank you for the job well done. I really appreciate your effort. There was an issue. A lawyer had to, a tenant got a letter from a lawyer. And the lawyer, hello, sir. Hello.
I'm hearing you. I just have to mute my own so that it doesn't distract you.
Okay. So the letter was written to the tenant 3 months to the expiry date of his last tenancy payment. Now, even within the 3 months notice, when he still has 3 months tenancy fees with the landlord, they have started renovating the building or while he's still there, removing the window, dirtying his room, stepping on his properties. Please, what can one do about this? What can one do about this?
You know, in the course of this lecture, I made mention of trespass. Is that correct? Hello, Galazi. 810.
Yes, yes, sir.
I made mention of right, trespass. Now, let me tell you this. Before I go into answering your question, I want to ask, was there a contract agreement between the landlord and, or was it an oral tenancy?
There was not any agreement. It's only when the money finishes, he pays again. When the tenancy expires, he pays again. But this time, is the time they say they want to use their father's house. So they gave 3 months notice. And even just after they gave the 3 months notice, they started removing doors, removing windows, while this person is still occupying the building, dirtying and stepping on his property.
Now, hear my analysis.
Okay.
When I was discussing, I said, except it is only the law that will limit the issue of, it is only the agreement that will limit the period of notices. Now there is no agreement.
No.
Now, if there was no agreement, then the law will come into full force. Since there was 3 months left,
yes,
if you are paying every year, then you are entitled to 6 months notice. The notice they would have given you would have ended. Let's say that 3 months remaining is this thing was happening. Let's say it was happening in August, September, October. Your rent was to end by October. So that notice they would have given you should have been 6 months notice that would have ended in January.
Okay. Okay.
Do you understand what I'm saying?
I do, sir.
Now you will pay mean profits for November, December, and January before you vacate. So even if they enter that place, you can still sue them. If you have record of evidence of them entering that place when the rent was subsisting, I can do a case for you for trespass.
Okay. But there was no agreement.
On to you while you are living there. There was a trespass to your possessory right while you are living there. If you have video evidence, records, and everything, we can do a case of trespass against them.
Okay.
And claim, yes. We can claim damages.
Okay, you're right. So, then even there was a condition that I'm sorry. There was even a condition that if one wants to stay beyond that time, one will have to pay double tenancy fees for the 1 month they will allow one to stay. Please help us.
That's extortion. It is against the law. Why didn't you? Why when these kind of things are happening? Why you don't have a lawyer? See, let me tell you, life expects you, each individual, to have a lawyer. That's why we don't have enough lawyers in Nigeria. Unfortunately, the ones we have are even trying to jackpot, and some have jackpot. So a lawyer is expected to be with one citizen. You're expected to get in touch with your lawyer. That kind of thing shouldn't happen. Let me tell you when your landlord can have power to do things. After that, if there was an agreement, I keep saying it, and on the eve of that 31st of October, on the 1st of November, he will have power to enter there to serve you his intention to recover. That is 7 days. Now that 7 days will end by 7th of November. Thereafter, he cannot do anything. He can even remove the window, remove the roof, remove everything he wants to remove, because there was an agreement. But in this instance, you are saying there was no agreement, so the law will reckon with it. You know, in my introduction, in my earlier comment, I said the agreement limits the law. And I mentioned section 14, the introduction to section 14, where he says, except expressly provided. That express provision is agreement, unquote and quote unquote, quote and unquote. So, does that answer your question, or do you have any other thing you want to clear on
sir.
that?
Thanks for the answer. Then another thing. Please,
okay.
I was a bit late before joining. There was also a situation where the tenant decided not to pay the landlord. 6 months, 1 year, 1.5 years, even 2 years, 3 months. Until the landlord had to sell the house before about 4 of them in the building would vacate the place. Please help us. I don't know whether we have discussed this before I joined.
Now, let me tell you. Now, listen attentively. Was there agreement when the tenants entered?
Yes, there was.
If there was an agreement, as at the time that agreement allows, there were no more tenants. And after the agreement, they decided that they are not paying. They are not tenants in that place. Okay. You can even remove the roof, throw them out as you want, after giving them 7 days notice of owner's intention to recover. They are no more your tenants. And if you do anything inside that premises, they cannot sue you for trespass. Because it is only tenants that have the power of exclusivity. You know, I discussed about exclusive possession. So it is only the tenants that have the right of exclusivity that can sue for trespass. But where they are not having that right of exclusivity, there was no exclusive possession, then they cannot sue for trespass. The only thing the landlord will always be conscious of is suing him for trespass. But where there is nothing, no more exclusive possession, the tenancy has elapsed, you have issued notice of owner's intention to recover, and 7 days has passed, then you can just enter there and vacate through the. Don't be surprised that the lawyer is telling you this. Some people will say that is self-help. The law frowns at it, but my brother, I must be practical with you. I will do it, then go to court. Like APC will tell you, go to court.
Thank you, Barrister. Thank you, Galaziwa, Mr. Deleke. So we have Mr. Abimbola Adekoya, my boss. My boss is raising his hand since. I'm sorry, sir. Mr. Abimbola Adekoya, you have the floor, sir.
Thank you very much, everybody in the house and the organizer of this. This is very, very good, and we thank God. The barrister, I just want to ask 1 or 2 questions. The first is this. You talk about being practical. So the one I want to ask is a practical one. The first one is, you are talking of the government rates and the tenant who's looking for a house should insist on government rates. Don't you think that will put that tenant in a big issue? If you come to my house and you are now putting the government rate. Are you hearing me?
I got your question. The question is this.
If you come to my house and you are now quoting the government rate, I'm telling you, you may not likely have the will, because it happens around this area. This area is staying, if you get down and you start telling them this is what the rate is, they will tell you to go and look for the local house.
Let me cut you short there. Let me cut you short there. You see, there is recent exercise of the state government was trying to do enumeration of houses, residential houses. You see, every property that comes up should be within the net tax net of every government. Every government should know about the existence of each property in an area. A lot of things are not good, are not done well in Nigeria. We are wasting money and we are wasting so many things in this country. The government is losing a lot of things. Most landlords don't pay grant rent, grant charges, land charges, grant charges, and land levies. Are you understanding me?
Yes,
There's what you call white paper. The governor,
you are getting me out of context. What I'm
no, I got you right. You are saying that how can somebody come in your house and start quoting what the governor has quoted as the amount for that house, isn't it?
That is it.
So I'm laying a foundation to answering the question.
Okay.
Now, when the landlord has all the properties within the state in his tax net, he knows all the properties. Now, there should be expected to be rent control tribunal. Now, landlords association, they know the value of things. They know when the properties are increasing. The governor cannot just sit in his office and write out this amount for Kwari, this amount for Deda, this amount for Adigbe. There has to be a committee that landlords will sit on. Economic advisors and experts will also sit on. And they will deliberate and come up with even an amount that will be specific, that you will know that that is befitting. There is no way you will expect a governor, areas like Okerewo, a room self-contained, the governor will now go and put it at 100. It's not possible. You see, it was Buhari that started waking the economic life of Nigeria at a point. I appreciated what he did by passing fiscal policies, fiscal laws every year. Every year, economy is expected to be reviewed. When they are reviewing economic indices, they are reviewing a lot of factors. Now, when they are reviewing the factors, one of the factors they will be reviewing is rent. Because they know if you are living in Okelewo, if you are living in Adigbe, if you are living in Kwari, which is expected to be a residential areas, Okelewo is a commercial area. So a room self-contained, if somebody wants to use it as an office, you are paying around 300 to 500,000. Then you that left residential areas to come and stay in Okelewo, your cup, you have to drink it. Now, when the governor, because the governor has to be practical, he has to be realistic with economic realities. There is no way you put your house in Kwari less than 200,000. Now, what is the essence of these things? To enable the landlords to pay ground rents, because they also will pay ground rents. They also will pay land use charges to the government. How many landlords are doing all these things? Do you now see where the loophole is coming from? So yes, by the time a landlord is now, by the time the landlord is now trying to go beyond 200,000 that has been designated for Kwari, the tenant can raise, the law will say, no, you cannot do that. And the rent tribunal will come in and tell you, you landlord, you cannot do that. And that place will be sealed up. That's what the law says. Now, there are instances where landlord will even undercharge what the rent the governor has fixed. The landlord may look at it. The economy is not looking good. And the government is saying that 200,000 naira for houses in Kwari, I want to collect 180,000. But the law says what the tribunal has fixed is what the tenants will pay. Then later, the landlord can now give them back 20,000 naira. Did you get that law?
I think what you meant is yes, I agree with you.
Good.
But you see, like so what I was saying, practically, if you put that forward before you get a house, the landlord has a right to reject you getting it. Two, if you are there and the man feel that that is you bring that, I'm just talking of being a practical thing. You bring that up for the landlord, okay, he will keep quiet. He will take the other dimension. You said that if you are able to link it up, that is why he want to get you out. He will not, if he's smart, he will not be able to link it, and he will tell you to go out. You must go out whether you like it or not after due process. That's just my observation. Thank you.
I agree with you, but then the problem is that there is housing deficit in Nigeria. If it were to be where houses are not, even landlords are looking for tenants up and down. In abroad, landlords look out for tenants. Yeah. But recently in Canada, it is the other way around now. As at 2020, 2021, landlords were practically competing for tenants. In America, they compete for tenants because most landlords are on mortgage. Do you now understand where the problem is, sir? It is inherent in the deficit, housing deficit in Nigeria. Otherwise, don't forget, tenants are not slaves. They also have rights, just like the way the landlord has rights. That's why the law comes into balance. But I understand what you're saying, that if he comes in with that mindset, you will just tell him the house is not available. But if there is no housing deficit, if your house is not available, he goes next door. Is that not correct? Mr. Bimbola Adekoya.
Yes, it is.
You totally agree with me, sir?
Yes, I do.
All right, thank you very much. And that was quite a very brilliant question.
The question here next is that we have some graduates of estate management who see them. We have some graduates of estate management who now see themselves as estate agents. They are involved in all these agency stuffs and co. Among the attorneys and the estate agents graduates, estate management graduates, who are the real owner or who are the real practitioner of estate agency, house agency, and co?
Like I always say, a lot of things are not right in Nigeria. This is a sector that is never regulated. You can't just be a realtor in US or in Canada without license. It's not possible. You cannot just be a house land agent without license. Who has licensed you? Now, a graduate has gone to the school and studied estate management. That certificate is his license. He's experienced. The kind of experience is acquired in 4 years or 2 years for those who are doing ND and 4 years for those who did HND. You cannot compete it. My first master's degree was on secure credit transaction. That is license. And then as a lawyer, I was taught property management because I did land law. And essentials of land law are property management and the rest of it. So when somebody comes up, somebody that was into mechanics before, things were not going well, he just decided he can see 1 or 2 properties to manage. He becomes property agent. The problem is that lack of licensing, lack of control, lack of regulation. If it is properly regulated, some of these agents, okay, I have an experience. A landlord puts his house out, both rent and the maintenance, what they call service charge, 70,000, rent 170,000, everything 240,000. An agent went and told the tenant 350,000 and collected the money with the hope that he will come and give the landlord 240 and put out with about 110,000. You can imagine the audacity. Now, somebody who did proper estate management will never think in that direction, because in the course of his lectures, he would have been taught ethics. He would have been taught ethics of his profession. And one of the ethics would have been non-exploitation of maybe gullible or vulnerable potential tenants. But because there is no ethics, the agent does not care. His interest is that 110,000 he's going to collect. And anybody that will stop it, he can kill the person. So these are the things that people should look at. But I blame landlords that hand their properties over to agents. I blame them. Let me tell you, if you can put your number or your details in front of your house, it's enough. People should go out and look for houses. When I traveled, the person I was to stay in his house was to get another accommodation. We walked the streets. We are looking for a house. Do you understand what I'm saying? And they pay monthly there. They pay every month. And the payments they are paying includes gas, electricity, internet, everything included. You know, I mentioned it earlier. You should be able to know from the landlord what you're paying for. So the realtors there, they are licensed. The landlord, you approach the landlord or you approach the agent because the agent is licensed. So here, people are just doing anyhow. So does that answer the question?
Thank you very much, sir. One of the major takeaways for me in this webinar is this. For today, most of the agreement I've been signing for house rent and food, I never had a copy. Imagine. So I think it is now high time for me, in fact, to call the agent. I need a copy of the agreement that I signed when I wanted to move into the premises. And I think this should also apply to everybody that is also in the same shoes. But without the agreement.
But you paid for it. How can you pay for something and you are not getting it?
That's what's telling.
I'm surprised if somebody enters a shop, ShopRite or Just Right. You buy mosquito coil, you buy bread, and you are leaving, you did not collect it. Is that not shocking?
Most times you don't do the copy, just sign.
Because a lot of tenants are desperate and they feel they are at the mercy of the landlord. Let me tell you, the landlord built his house for business. If you don't take that house, it will pain him. It's these agents that make it look like that. They punish tenants because of their exploitative mindset. They make the landlord, they promise Eldorado and windfall to the landlord. The landlord will think that everything is all good. And they come and mess up the whole thing. They make the tenants to be at the mercy of the landlord. It's not supposed to be like that. When you enter, a contract is a contract. You need the paper. I applied for, which country was that again? UK. They asked for my rent agreement. They said if I'm a tenant, I should produce it. I said I'm a landowner, but I'm residing in somebody's apartment. He said, okay, produce the. People here that have applied for UK visa who attest to this, I'm saying, they will ask for it. So if you don't have that, what do you produce? They usually ask for it. My own time, number of times they ask for it. So,
thank you very much, Barista. Everything you have taught us are very, very practical. Yeah, this is the third webinar that you'll be taking. We really appreciate. You took us on student rights in their schools. You also took us on employers and employee rights, which was last week. And today we have done tenancy, tenant and landlord rights, which is very, very touching. I myself have personally learned a lot from this. I gained a lot. All these learnings, all these things we have learned are priceless. We really appreciate you. And at this moment, kindly permit me to present an award to our barista to show our small level of appreciation is just accept us the way we are. I will let her go. Okay. The presentation will go online now. We want everybody to see. Yes. We want to present this to the barrister, just to appreciate him the little way we can. On behalf of the Board of Trustees of Accurate Creative Mind Foundation, we present this award to you in recognition of your teaching, which was incredibly informative and engaging. Thank you for sharing your legal knowledge with us. We appreciate you.
I'm very grateful. Thank you.
Thank you, sir.
Thank you so much, sir. Really appreciate you.
This is wonderful. I want to appreciate the foundation. Accurate has been doing excellent. The awareness have been overwhelming. And this is very beautiful, I must say. So, on behalf of myself and our firm, CJP Oguba and Co, we humbly accept this award and we dedicate it to knowledge generally, because the essence is knowledge. And I remember when this foundation was formed, the enthusiasm you had to bring up this foundation was to inform the uninformed. And these successive weeks, we have also navigated through informing people on certain things, starting with student rights, employment rights, and today we have tenancy rights. So, but what I can only say is that I will contribute my quota. It is my responsibility as a lawyer to inform the public. And this commitment I'm also giving on this day as my covenant in acceptance of this great gesture from your foundation. I'm grateful.
Thank you so much, sir. Thank you, sir. God bless you. God bless you. God bless your pen. And God bless your family, sir. Thank you. One, we really appreciate your presence. We appreciate your time. So till we meet next month again. Thank you all.
Thank you.